It's my pleasure to introduce the next speaker, Ambassador Rapp. Ambassador Stephen Rapp served as U.S. Ambassador at Large for Global Criminal Justice from 2009 to 2015. In that role, he coordinated U.S. government support to international criminal tribunals, including the International Criminal Court, as well as to hybrid and national courts responsible for prosecuting persons charged with genocide, war crimes, and crimes against humanity. He was credited with arranging for the United Nations Commission of Inquiry and other prosecutorial authorities to gain access to a cache of 55,000 photos documenting torture by the Assad regime. From 2009 to 2008, from 2007 to 2009, Ambassador Rapp served as prosecutor of the Special Court for Sierra Leone, where he led the prosecution of former Liberian President Charles Taylor. His office achieved the first convictions in history on crimes against humanity charges for sexual slavery and forced marriage, and for attacks on peacekeepers and recruitment and use of child soldiers as violations of international humanitarian law. From 2001 to 2007, he served as senior trial attorney and chief of prosecutions at the International Criminal Tribunal for Rwanda, where he led the trial team that achieved the first convictions in history against leaders of the mass media for the crime of direct and public incitement to commit genocide. He received a BA from Harvard College and a JD from Drake University Law School. Ambassador Rapp, thank you for joining us today.
Thank you. Thank you for that great introduction. It's been wonderful being here for the last 2 days with all of you, listening to these speeches and meeting the people involved in here at the College of Charleston, and learning about the Mrozes, about John and Karen, and their legacy, which lives on here in a school and an institute and in this annual summit. And I'm honored to be part of it and hope to be back again in the future. The question that I try to answer, or will try to answer in this, in my remarks, and then open it to your questions, is the question of whether leaders can get away with mass murder. And you know, for all of history, up until about 80 years ago, the answer was an unqualified yes. Certainly that's what Adolf Hitler observed when he called his commanders to Berchtesgaden in his mountain retreat in southern Germany in August of 1939, just before he launched World War II with the invasion of Poland. And he said to them, conduct yourself with total brutality. You don't have to worry about anything. Who now remembers the Armenians? He was referring to the genocide of the Armenians that occurred just 23 years beforehand. The murder of more than 1 million of the Armenians of Eastern Anatolia, for which there had been no justice. The lesson was impunity. And so Hitler could feel free to launch an aggressive war, even though in 1928, Germany and other states had signed a treaty banning aggressive war. He could proceed to not just violate the laws of war, that were in the Geneva Conventions and the Hague Conventions that Germany had ratified. He could proceed to commit massive crimes against the civilian population of Europe, most prominently the Holocaust of the Jews of Europe, murder of 70% of the Jews, men, women, and children, but also other civilians, at a total cost in human life of some 40 to 45 million men, women, and children. Because as of 1938, the expectation, well, certainly there was no rule about a leader doing anything to his own people. A leader could kill, persecute, torture, disappear 100,000 of his own citizens, and could and not be subject to any international rule that had been established at that time. And from the pattern of the past, generally die comfortably in the presidential mansion, or at best, in the case of overthrow, in a comfortable exile, where they'd be able to take a lot of the resources they'd stolen from the country. And at the international level, even with treaties like the Kellogg-Briand Pact Against Aggressive War of 1928 and the Geneva and Hague Conventions, when a leader through the state committed violations of those conventions against other states, against their populations, against the people of occupied territories, generally at the end of that conflict, even on defeat, the compensation would be perhaps adjustment of borders or payment of reparations. But certainly as far as the leader was concerned, if his people were willing to keep him, he stayed in power. And if he lost power, again, it was likely that safe and comfortable exile. The rule was as it was described by Thucydides, writing about the Peloponnesian War and about the sack of the Republic of Melos in 416 BC. Melos was neutral between Sparta and Athens, and Athens resented that. So Athens, we think of them as the more noble side maybe, but in that particular case, that neutrality was objectionable. And so the Melos was attacked by the Athenians. All of the men and boys were slaughtered, and the women and girls were taken into slavery. And as Thucydides said, the rule is the strong do what they can, the weak suffer what they must. That ended at Nuremberg 80 years ago. It wasn't a certainty by any means that the leaders of the Nazi regime would be put on trial. Churchill and his Lord Chancellor, Lord Simon, recommended that they simply be put against a wall and shot. But it was thanks to President Truman and his nomination of one of the greatest jurists in the history of the United States, Judge Robert Jackson, who'd been Attorney General of the United States, but nonetheless ruled against the Roosevelt government in dissenting in the Korematsu case, for instance, the internment of the Japanese in America by the Roosevelt administration. He said that was illegal. Courageous judge, appointed to take a year off from the Supreme Court, leave his cases behind, and negotiate a statute with the other three major powers involved in the defeat of Nazi Germany. They did that over the course of 3 months in London in the summer of 1945. And they came up with a treaty with many very important innovations. A key element was that states, we heard earlier, one of the speakers described, Dr. Powell, you can't put states in prison. Of course, you can't put states in prison. They're in a sense abstract entities. But states are controlled by people. People like Hitler take over and conscript the people of a country and the institutions of the state and all the power of that state to commit the crimes. It's individuals that should be held to account. And as they said in Article 7, the official position of those individuals, whether as head of state or as responsible officials in government departments, shall not be considered as freeing them from responsibility or mitigating punishment. The provisions also made it clear that those individuals could be criminally responsible for the acts undertaken by state forces under their effective control. For the source of the law, they looked to the Kellogg-Briand Pact and said aggressive war is a rule for states. The leaders of states need to comply with it. So if you launch an aggressive war or plan to launch an aggressive war, that's a crime. If you violate the Geneva Conventions, which had occasionally in the past been enforced by states against low-level soldiers who stepped out of line, you who caused those violations could be held criminally responsible. And then additionally, there was a new aspect of law, crimes against humanity, violent acts such as murder and enslavement committed as part of a widespread or systematic attack against civilian populations, establishing that leaders held a duty to all humanity beyond that set forth in the statutes and agreements made by states. Jackson gave, in my view, the greatest speech in a courtroom when he opened the trial on November 22nd, 1945 at Nuremberg. And in the second minute, he stated the fundamental premise. The common sense of mankind demands that the law shall not stop with the punishment of petty crimes by little people. It must reach men who possess themselves of great power and make deliberate and concerted use of it to set in motion evils which leave no home in the world untouched. 10 months later, after the presentation of evidence that was almost exclusively the Nazis' own documentation, 18 of the defendants were convicted, 3 were acquitted. And there followed 12 subsequent trials at Nuremberg, at which the lawyers and judges who had corrupted the law of Germany in the aid of Hitler's mission were prosecuted, as were doctors and diplomats, the industrialists who manufactured weapons, and the commanders who used those weapons in forces such as the Einsatzgruppen to deliver death to millions. The Allies could have just shot those guys. But as Jackson said, this was a necessary tribute of power, which they had, to reason, the judicial process, where guilt would be determined according to the rules of court, and where those even suspected or known by all the world to be guilty, who couldn't be proved guilty beyond a reasonable doubt, would be acquitted. After that, there was a long break in this international justice project through the Cold War, when it was impossible to get the kind of agreement that had been signed in London, which of course included the Soviet Union, who were among the judges and prosecutors at Nuremberg. But after the fall of the Berlin Wall, and after horrible atrocities began to be committed in the former Yugoslavia, and after close to 100,000 innocent civilians were killed in campaigns of ethnic cleansing to claim to essentially establish ethnically pure territory where those were of a different ethnicity or a different religion were murdered or tortured or raped in order to drive them off. After those crimes were committed, the Security Council of the UN did something very interesting that many thought was, surprising. They looked to Chapter 7 of the United Nations Charter. Chapter 7 says the Security Council can act in the interest of international peace and security to take what measures are necessary to restore peace and security. And so one of those could be a court, which would take out some of those guys who are committing those crimes, take them at least out of the situations where they were murdering and raping, and where the story could be told and the truth established. And in the end, those individuals convicted. That would help restore international peace and security. So on that basis, they established a court with a statute, with judges to be elected by the General Assembly to hold perpetrators to account. Now, when this was initially done, there was no great expectation that would result in very much. Many people said, well, what they should do is send in peacekeepers, and armed police, put boots on the ground. Well, they just put some shoes on the ground in the Hague, lawyers and judges to enforce the law. Before it was done, 161 individuals were charged. An amazing thing, all 161 of them were brought to justice. As major states supported it, they conditioned the movement of states of the former Yugoslavia into the European Union on compliance. They conditioned the elimination of sanctions on compliance with the rule of law. And so the president of the former Yugoslavia, Milosevic, was arrested and transferred to The Hague, as were leaders such as Radovan Karadzic, the head of the Republika Srpska, whose forces were responsible for so many of the atrocities committed in the former Yugoslavia. And Ratko Mladic, who was an individual eventually then convicted of the murder of 8,000 Muslim men and boys at Srebrenica, determined by the court to be genocide, as well as other crimes against humanity and war crimes throughout the conflict. A year later, the UN Security Council did the same thing when horrible crimes happened in Africa, in Rwanda, where 800,000 men, women, and children were murdered in 100 days, not by spontaneous combustion, but by a planned genocide, logistically supported and executed and expanded to cover every hill and commune, organized by political and military leaders with the aid of others from media and business and religion, all to preserve their power and privileged position. And as you heard, I went to that court in 2001 and led the media trial, which prosecuted the individuals who founded the so-called hate radio station, RTLM, and the publisher of a newspaper or magazine that had also incited action against the Tutsis of Rwanda, who were referred to as cockroaches. After a trial of 27 months, those three individuals were convicted by our three-judge panel. First, people involved in the mass media in the crime of direct and public incitement to genocide. Thereafter, I worked as chief of prosecutions, the organizer of the trial teams, of which we had 12 that prosecuted the leaders that we had of the genocide in these various establishments: political, military, territorial, religious, media, business, arrested them in 26 different countries, brought them to Arusha to try them. And though it's been a long journey and only a few of the cases have recently been resolved, every one of the 92 individuals, those that remained alive, faced justice. Thereafter, I went to a new court, one that I liked, that I thought was had an even greater chance of success, and that was the court in Sierra Leone that was established in an agreement between the Sierra Leone government and the United Nations, requested by the government, that was mixed in the sense of having 60% of its employees from the country itself, some of its judges from the country, others international. I was prosecutor, the third prosecutor. My deputy was from Sierra Leone. And that court conducted its trials at the scene of the crime, tried 9 leaders of the various factions that had been responsible for the murder of perhaps close to 100,000 people, and massive sexual violence, sexual slavery, and also the crime that, if you've seen movies like Blood Diamond, that conflict was famous for, the amputation of at least 10,000 men and boys, and occasionally women, of their hands and arms. We allege that the leader of the country next door, President Charles Taylor, was in fact a major supporter in terms of training and arming and assistance of the most brutal of those militia, and that he should be tried by our court. He was initially, there were efforts to arrest him. He evaded justice. Eventually was overthrown in his own country, went to a safe and comfortable exile. And just before I came to be prosecutor, he was arrested in Nigeria. There was finally cooperation with the court, go into exactly how that was accomplished. And he was brought to justice, and we were eventually able to convict him for 11 counts of war crimes and crimes against humanity, and sentence him to 50 years, which he's today serving. Thereafter, as part of the United States involvement, and indeed the United States have been a key supporter at Nuremberg, at these Yugoslavian, Rwanda tribunals, Sierra Leone special courts, and other special courts, was appointed to be ambassador at large by President Obama, had ambassador at large in this area since the 1990s, appointed by President Clinton, but President Bush, second President Bush, also had ambassadors at large, which is a recognition of the fact that these courts don't have powers themselves. They may have investigators, they don't have police forces. They have a limited ability to collect evidence on their own. Fundamentally, they can't make arrests. It's states that are required to make that arrest. And so if a court's going to succeed, it needs state support. So my position was to work to establish that state support, to provide it from the United States, but also to encourage other countries to do it. But this was all part of global justice. Justice for Rwanda, justice for Yugoslavia, justice for Sierra Leone, but what about justice for other places in the world? How do you achieve justice there? And so the mission was to work everywhere with the victims and survivors to find a pathway to justice. That's complicated, as we know, by the fact that the United States had not joined the International Criminal Court. It does have 123 countries, every country in the European Union, every country in South America, almost all of our best allies are members of it. Canada was a leader in establishing it. At least during the Obama administration, we took the position that we wanted to be supportive of the court in cases that didn't involve Americans, and none did during my tenure. And so we supported its cases and actually provided evidence and provided rewards to bring their fugitives to justice. Indeed, two of the most serious offenders, the two most serious offenders so far convicted at the ICC, mission in Central African Republic. The other, the person came into our embassy in Kigali, Rwanda, and said, "Take me to The Hague." And we took him to The Hague. But we tried to support the court and talk a little bit about where we are today. But the court's limited. It doesn't have the kind of state support from the United States or even from the state parties to provide the sort of teeth that are necessary, the conditionality that the Yugoslavian and the Rwanda court had. So the majority of its warrants are unanswered. At the moment, it's seeking at least 15 individuals. We know where they are. And it has, at the moment, no cases that are yet pending. It's finishing the trials of the people that it has in custody. On the other hand, there's an impact. The individuals that are on the court's wanted list don't like being there. They're pariahs. Putin has enormous power, and indeed, no one in Russian leadership has ever been accountable for anything. The expectation of Putin as a leader of Russia is that he could get away with things. But when he thought he could go to the BRICS conference, one of the organizations that he established of countries, Russia and China, Brazil, and South Africa and India, thought he could go there to South Africa. The South Africans said, "You come here, you're going to be arrested." Following year, Brazil held the conference. They've been critical of the global north, but they said, "Our law says you have to be arrested. They'll have to be arrested." So his wings are clipped. And no matter what happens, the court order doesn't go away because of politics. Not at the international level. There's no rule that would permit it. Security Council can defer a prosecution for a year at a time by a resolution, but those have to be renewed and those can be vetoed. So Putin will go to his grave with an indictment over his head. Recently, the court indicted General Huang, the leader of Myanmar, brutal military coup, the Tatmadaw, the military of Burma, famous for the genocide of the Rohingya, killing 10,000, burning 300 villages, driving 800,000 over the line into Bangladesh, into squalid camps. He's now charged. And of course, we have the more controversial indictments of Prime Minister Netanyahu and his former Minister of Defense and an Hamas leader by the ICC. for crimes committed in Gaza and in southern Israel. Israel objects vociferously and is seeking ways to obstruct that, and that's led to Trump establishing sanctions again against the ICC as he did the last time. That's not the answer. People charged by the ICC. The answer is to investigate these crimes themselves under their national system, do it genuinely, then in the same way that Ambassador Rapp described at corruption court, the rule is complementarity. If you do a genuine investigation, even if there's no conviction, if it's a genuine case, you pursue it, the ICC has no jurisdiction. Or you go to court with the ICC and you fight it. You don't obstruct the rule of law. But the ferocity of the opposition indicates that these indictments bite. They have an effect. No one wants them hanging over their head. And indeed, in most of the countries of the free world, Netanyahu cannot go without being arrested. There's also other good news. And it's a reflection of justice, not from the top down, not by great powers in London or people writing treaties in Rome. It's a reflection of to some extent, of the legacy of these tribunals and the expectations that they've established. If a Milosevic can be held to account, if Prime Minister Kambanda, the Prime Minister of the genocidal government of Rwanda, can be held to account, if a Charles Taylor, the President of Liberia, can be held to account, what of our leader? What are the crimes committed against us? How do we find a pathway to justice? There's an explosion of activity by civil society and victims groups. And they're working with the new tools, with the social media, with the ways in which you can download videos of these guys showing themselves proudly committing these crimes and have this verified through forensic methods. Efforts on the ground where UN investigators dare not go, working to collect the evidence and the documents on the battlefield. And sometimes in areas and intelligence centers that have fallen to one side or another during a battle, and you can get the documents out. I'm chair of an organization now, the CIJA, Commission for International Justice and Accountability. There's 40 Syrians that have been working for the last dozen years bringing documents out of Syria. And we have 1.3 million pages of regime documents that I've said and believe, because I know how powerful they are better than we had at Nuremberg against the Nazis. Heard about the Caesar photos that we brought out. There's military photographers, codenamed Caesar, who finally, after the overthrow of Assad, is announced his name to all the world from his exile in a Western country as Farid al-Matan. With pictures that our FBI in the United States determined in the case of 11,000 people tortured to death, photos taken by the regime photographer himself as part of their record keeping. These are real people and real events. And these cases have then gone to court in various countries when some of those perpetrators have turned up. Countries increasingly recognize that, and it's politically strong. And I know Ambassador Rapp, when he was Minister of Justice, was instrumental in Canada taking the role of there weren't going to be a safe haven for war criminals. It's the same, and the laws in the United States have become stronger and strong. And so when people turn up in your country and they've committed these crimes, you can use the evidence that's gathered by groups like this, that's sometimes consolidated by these new mechanisms established by the UN, to build prosecutions. And so we had a major Syrian torturer, Colonel Rasselin, convicted in Koblenz, Germany, sentenced to 58 murders and sentenced to life. We have a torturer from Syria that was arrested in Los Angeles, Samir Othman Sheikh, tortured people in Adra prison allegedly, and was also involved in the mass suppression that is part of Assad's murder of 600,000 of his own people to try to remain in power. He'll soon go to trial in the Central District of California. And so these opportunities are opening up around the world to hold perpetrators to account. So the message is fundamentally sent to anybody who's involved in these crimes. well, there may come a day that you want to get out of here. You may have taken some of your money, right, forms of grand corruption, which often accompany these atrocity crimes, and sent it off to some bank somewhere. You may have your kids in school in some European country because of your school, you've blown up all the schools in your own country. And for as long as you live, you worry that you're going to be charged and convicted. Of course, at the end of the day, what we prefer, what we got in Germany after Nuremberg, the Germans began their own cases against people at Auschwitz, against the leaders at Auschwitz in the 1960s, and even today are holding 100-year-old persons who were camp guards to account for what they did in Germany's name. The best justice is the justice that happens at home, and that's what we hope can now happen in Syria. I just returned on Wednesday night from my second trip to Syria since the end of the war, the overthrow of Assad, a day that none of us thought would ever happen. I was there, and a week afterwards was ecstasy in the streets as people were continue to cheer, honk horns, and go to places that they never dreamed that they could go to before. This week, I was with a group of Jewish leaders from New York, Jewish leaders coming back to worship in the synagogue, where 100,000 Jews lived and worshiped in 1900, and where they've been forced out from in 1992. There really is hope of justice in this situation. And there's enormous expectation like that I described. I mean, as I visited the detention centers and I visited the places where the Caesar photos were taken, and the prisons where the individuals in those photos drew their last and painful deaths with eyes gouged out and drill holes through their heads, emaciated, electrocuted, poured on with chemicals. Saw places of mass graves, one that may hold as many as 75,000 of those tortured to death in those squalid dungeons. And all around me were families, survivors, seeking information on their brothers, their sons, their daughters, their other relatives. The government says transitional justice, at least as the interim president described, it's the #2 priority. Working with them now to get to all the documents, not just the 1.3 million that CJA was able to get out of the country. There are, as we've surveyed the various centers, even though there's been a lot of destruction, there are at least 20 million pages of regime documentation. They'll tell us a lot about what's happened to the 120,000 people that are still missing, that are probably in those mass graves. There's the need for the forensic identification of those remains and people survivors receiving the remains of their loved ones. And it all has to be part of a process of justice that has 2 parts to it, really. One is the formal truth-telling exercise where people know what happened, where the truth is revealed comprehensively. That takes a lot of work, but people are entitled to that. And then there's the narrower task, in my view, of prosecuting those with the greatest responsibility. Not everybody. Government's already said conscript soldiers shouldn't be prosecuted. Others that were forced to go along with this regime shouldn't be prosecuted. There should be opportunities for lower and mid-level people to rehabilitate themselves. But certainly those that were involved in mass murder, including eventually Assad himself, with the pressure on the Russians, may not give up Putin, may give up somebody that lost the country for them. The day could arrive when that particular killer, that particular leader, is held to account. It's a difficult time for human rights and for norms. People are writing books such as The End Times for Human Rights. It's difficult to do anything in the Security Council of the United Nations. It used to be possible to establish tribunals or to refer cases to the ICC. Now there are certain vetoes. Increasingly, authoritarian governments oppose any efforts at justice or accountability. Even a great country like this one is led by someone who's dismissed the idea of holding people to account as pardoned, convicted war criminals who've committed and been found guilty in military justice. But the demand for justice is there. The work of building the documentation has never been stronger. There's support for it by willing governments, maybe not the United States, but others around the world. There are precedents that have been established that allow for justice at the national level, where the crimes are committed after transition, in third countries, where there's some connection to the crime, where the victim came from that country or where the perpetrator turns up, and certainly at the international level, when there's a regional body prepared to establish a court. So the answer to the question in 2025, can leaders get away with murder? No. Some will, but not for certain. There is, like there always is in the criminal law, the expectation of some that they'll get away with it, some that they'll beat the rap, some that they're so powerful that no one will touch them and no one will testify against them. But the risk of that prosecution, because of what's been achieved, because of the strength of the evidence that's being brought forward, is greater all the time. And that's the reason why some can be deterred from violating these essential rules of humankind. Heard earlier, well, maybe international law is all gone and there's no hope. You know, I'm an optimist. You give me a damp glass and I'll tell you it's half full. But I do believe that those norms will be enforced because we've seen it done. And because of that, there's hope for a future where our lives are not nasty, brutish, and short as they are in these conflict zones. Because without it, none of us are safe anywhere in the world. Thank you very much.
Thank you so much for these remarks. We have one microphone here and they'll take the other one. So there are any questions.
Ambassador Rapp, over here.
Oh, there you are. Hey, Ambassador.
I just wanted to say that presentation was riveting and filled with admiration for your work, your achievements. It's remarkable. 20 years ago this year, the General Assembly unanimously adopted by resolution the principles of the responsibility to protect arising from the atrocities and genocide that you referred to. And it was a commitment made collectively by the international community to act decisively through the Security Council, Chapter 7 if necessary, when there was evidence of genocide, war crimes, crimes against humanity, or ethnic cleansing, and the state in question was unable or unwilling to stop it. Those principles have fallen into disuse. The Security Council, as you mentioned, is dysfunctional. But do you see any prospect, any hope that the General Assembly's unanimous resolution might one day be brought back to life to provide the international community with a way to respond in real time and try to stop some of these atrocities while they're in process?
Well, thank you for that question, and thank you for your leadership in getting R2P adopted. I certainly hope so, and I'm involved with a global contact group of responsibility to protect 50 or 60 countries, including in various parts of the world, have meet periodically to discuss what can be done. Frankly, the approach that tends to be, the way we now talk about it, as we talk about complementarity, is the obligation is first and foremost the national level. It's the three pillars, basically. Your government's responsible to protect you, to do these things. And it's only when your government doesn't do it that we go up the chain to the regional, and then we finally get to the international level. And even when we get to the international level, pillar 3, so-called, doesn't necessarily involve going in with military. It can involve other steps like these courts, to be frank. And so to understand that this is something that enables efforts to build capacity at the national level and to develop and to work with civil society and to use this norm to actually enforce these rules in their national system is the way that we have to, I think, activate it at this point, because our institutions, such as the Security Council, which interpretation of R2P would basically say under Pillar 3, if you're going to take some kind of mandatory action, you need a Chapter 7 resolution. If you have a Chapter 7 resolution, then Russia, China, whoever can, of the permanent 5, can vote no and kill it. Finding a way around that is more challenging. Now, there are possibilities. As we've seen, Sierra Leone court was established by a country with an agreement with the United Nations, not done under Chapter 7. And it had jurisdiction over the country, the president of the country next door, because he committed crimes in that country. That's the precedent by which many of us support the establishment of an aggression tribunal over Russia, or the Russia's leaders, Putin himself and others that are responsible for aggression. ICC has jurisdiction, as you know, because of the declaration of Ukraine over war crimes, genocide, and crimes against humanity committed in Ukraine, but because of the special rules, there's nothing over aggression. So you can potentially establish courts if you have a broad base and hold someone responsible if they commit the crimes in the member state, in the same way that you're talking about in the Corruption Convention. If you use the banking center, if you put your money in another country, then you can gain jurisdiction. And so I think that we've got to look at some of those inventive sort of processes with a coalition of the committed working together, the countries that are committed to the rule of law to enforce these things. But ideally, of course, that has to be done in cooperation North and South, so that it doesn't appear to be North judging South.
Ambassador, do you mind using the handheld microphone?
Okay, we'll do that.
Hi, first I want to thank you so much for your knowledge and your insight today. My question is more on a domestic level. A couple of weeks ago, our president was unconditionally discharged for a lot of crimes that happened. You mentioned that position of power should not affect the punishment the person receives. How can we, as the young generation, ensure that our leaders are kept in check, internationally and domestically?
Well, I'm back to what Alan had said earlier about the ballot box. And indeed, if there are crimes committed, potentially those crimes can be prosecuted even at the state level eventually, even when there's been, say, pardons issued and when we've got questions of immunity at the federal level. But it is a matter of, committing ourselves to the rule of law, that the law applies to everyone, no matter how powerful. It's particularly important that it apply to the powerful. And I mean, that's why these international courts are important. There may come a day, when U.S. Takes action in territories of other countries that are part of international courts. We like to say, oh, we're not in the ICC, you can't touch us. But if I go to Toronto and I murder somebody, the Canadians are going to decide where I'm prosecuted. It's not going to be the United States. And if I go to a country and commit crimes and they're in a country that's given jurisdiction to an international court, I'm subject to that court as well. So there is some prospect of that. difficult as it is to imagine. And obviously we have the power of our own government being used now against the ICC to sanction its prosecutor, to make people like myself a criminal if I give him a phone call. And so it's it is a painful and difficult process when power is used to obstruct justice. But for some time that can be successful. But certainly in my career, I've dealt with many people who were enormously arrogant, who thought they would get away with everything, who sociopathically thought the world centered on them and every need they wanted, even if it involved taking a life or the dignity of another person, they could get away with. And eventually they faced their accusers, they faced witnesses, they faced survivors, they were held to account, and they're serving life sentences today. So I believe it can be done. Build the case, find the court.
Yeah, Ambassador, we have a question from the webinar. Thank you, Mr. Ambassador. In cases like those of Putin or Netanyahu, their ICC warrants will be elephants in the room of eventual peace processes. What is likely to be the standing of international justice enforcement in such a politically oriented situation?
Well, thus far, it's those warrants have stood even when there have been sensitive negotiations. You may remember that in Sudan, we had a warrant eventually for the crime of genocide against President Bashir of Sudan. At a time, the United States very much wanted Sudan to live up to an agreement that it had reached with South Sudan that would allow South Sudan's liberation. And there were those who said, well, we've got to do something for Bashir. We've got to get rid of that warrant. The ICC refused to. They can't get rid of a warrant because there's political interests for doing it. I mean, they could in the beginning perhaps not start a case if they thought there was a good justice process that was coming forward. They didn't need to do it at the international level. But once they've done the warrant, they can't get rid of it. Security Council can defer it for a year at a time. Some countries wanted to have it deferred. There were not even 9 votes in the Security Council to do that. And that meant there was no possibility of resolution passing, even though the United States also said we'd veto that resolution. It was nonetheless possible, working through third parties, to consummate that peace agreement for South Sudan to become free. He may want the warrant to go away, but it won't do any good. I prosecuted at Sierra Leone in 1999 after the rebels, those guys that were chopping off the hands and enslaving women as sex slaves and killing thousands, had taken Freetown, the capital, committed horrible crimes, raped the nuns in the convent, captured 2,000 children to turn them into either sex slaves or child soldiers. And they were controlling 2/3 of the country. Charles Taylor then, who was in fact behind them, helped do a peace process at Lomé in Togo. And one of the provisions was everybody's got amnesty for everything that's happened before now. That was in the agreement. The United Nations attached a statement saying, amnesties do not apply for violations of international criminal law. Well, stop. So when we eventually charged those people, they said, amnesty, we have it here, right here. Our judges ruled it doesn't apply. So they can negotiate for an amnesty, I suppose. They can put it on a piece of paper, but it's not enforceable. They will face consequences. It won't go away.
Ambassador Rapp, thank you so much for your remarks.
Thank you.
I think that we have to conclude our summit, but thank you so much for being here, for joining us today, and for our students who are interested in international careers, who are interested in foreign service and civil service, public service, please consider applying to the Global Ambassadors Program. You have seen Global Ambassadors have been participating in our program today, yesterday, and it's a year-long program. You can learn about it on our website at mrozinstitutes.coc.edu. And thank you for joining us. Have a good day.